My pleasure. This declaration I'll read out, but I'll give you just a bit of a background as to how we managed to trap the Crown. How the Crown managed to belligerently trap themselves into acknowledging before their Parliament, before the world's press, that there's them and there's us. The one thing that they most desperately did not ever want to admit. Now, what happened was when Arthur Phillip arrived at Sydney Cove, before he walked up the beach to make his claim, he stuck his foot in my mum's country, and by doing so, he subjected himself to our law. And our law is such that if you do not have a bloodline connection to country, you cannot own it. He then proceeded up the beach and stuck a rag on a stick in the ground. And as most of us know, if anyone's seen, he put the Union Jack on a stick in the ground, yeah? Wrong. The Union Jack wasn't even created until 1801. That's how badly you've been instructed in relation to your history. Okay, that's number one. Number two, they claim that at the time, and we have this in writing from all the Attorneys General, federal, territorial and state, that when Arthur Phillip stuck the stick in the rag in the ground, he took radical title and sovereignty for the King of England. The problem with that is manifold. For example, on 16th of July 1796, the Judge Advocate General of the First Fleet, Captain David Collins, recorded in his journal that he just had a lengthy conversation with Bennelong, who explained to him at that point in time, 8 years after they arrived, how that the tribal people maintained their hereditary title over their estates. So they obviously hadn't taken radical title and sovereignty till then. And then, just as the next major sort of blip on the radar, there's millions of documents in the middle of all this. 23rd of February 1836, King William IV issued the letters patent to establish the province of South Australia. And in those letters patent, he had a proviso. And the proviso was that the settlers were not to interfere with the native people's peaceful enjoyment of their own estates. Once again, acknowledging by way of legal instrument within the Parliament itself that the tribes were still the masters of our own realms. Not 1872, sorry, the Crown created the Pacific Island Protection Act. In Section 2 of the Act, it defined that wherever the term other places is used in the Act, it meant the Australasian colonies. 1875, Queen Victoria created an ordering council to amend that Act, and in amending the Act, in Section 6, it was made patently clear to everyone who needed to know that the jurisdiction of the Crown was not to be extended over the native peoples, whether in the Pacific Islands or the other places, meaning the Australasian colonies. And in Section 7 of that amendment, under the title of rights of the tribes, it says that the Crown was not allowed to extend or construe to extend sovereignty or dominion into the Pacific Islands and the other places, meaning the Australasian colonies. And that sovereignty and dominion was to remain with the chiefs and the rulers and the peoples of the tribe. Now, for the Parliament to operate, the Parliament itself has a set of rules called Halsby's Rules. The contemporaneous version for that period of time, from say 1870 to 1900, was Edition 3. Now, if you want to know what we can do with the law of the British Parliament during that period, we go to Edition 3, and if you have a look at page 337, paragraph 559, part 12 and 12.1, in part 12 it says that if they amend any of their law, the only thing they can do is amend it to improve the original intention. They cannot derogate from the original intention of the Act with any later Act. And in section 12.1 it says that they're not allowed to usurp the sovereignty of the tribes here in the Pacific. For example, the Maori assembled in Parliament at Waitangi, and that we are not allowed to usurp their sovereignty. So we bounce forward 25 years to this thing that everyone's worried about, which is the Constitution. There's only 3 letters in that word you really need to take notice of, and it's the first 3. Apart from that, that document relates only to British subjects. It does not relate to Australian citizens. It does not relate to the current Australian Parliament, and it does not relate to the people who own this continent. The reason I say that is because, in accord with previous law, namely the Pacific Island Protection Act Amendment of 1875, Section 6 and 7, when they created your Constitution, they included in your Constitution a section at Section 51.26 that said that they could not make laws for people of the Aboriginal race, okay? And at Section 127, it said that they could not count us as part of the population of the Commonwealth or any part thereof. The reason for that being, you were not allowed to usurp our sovereignty. You could not count us as part of you. Now, in 1967, there was a referendum, and there was the biggest smoke and mirror con job ever pulled. What happened was that everyone thought that by amending the Constitution that somehow miraculously Aboriginal people were being recognised by the Crown, and that was the end of it. It wasn't even the start. All they did was they removed the mention of their right to not make laws, or their obligation not to make laws for us in section 5126, and they removed their obligation not to count us as part of their population in section 127. The problem with that is that removing the two negative statements did not create a positive environment. And they could not make a positive statement that they could make laws or count us as part of their population because we did not give it to them. So then we had to get the High Court to acknowledge that effectively their parliament had no jurisdiction over us in our original birthright status. So fiddling around back scenes, there was a lot of documentation written and a lot of documents funneled down to people, and matters raised in the High Court in relation to section 44(1) of the Constitution, the most popular being Barnaby Joyce. But what was proven through those court cases was that any class of Australian has the right to have the Crown acknowledge, or force the Crown to acknowledge their birthright if they don't rescind it. Because as we know, Barnaby Joyce was removed from the Parliament because he didn't know he had New Zealand citizenship, but he had it. He hadn't rescinded it. It was a birthright for him. Well, the fact is that the High Court acknowledged by way of that Aboriginal Australians standing over here as citizens of the Crown also have a birthright over here as in our tribal capacity that they can't take from us. And that birthright is our birthright, our blood connection to our country that they cannot rule, govern or steal from us. And they didn't realise it. Then on the 10th of February 2020, the High Court handed down a ruling in Tom Love versus Crown, which said exactly that. These two black fellas, one born in New Guinea, one born in New Zealand, came to Australia. They were about to be deported, but they also had grandparents who were Wiradjuri and Kamilaroi, and therefore, because of their unintentional but nonetheless legally binding birthright, their blood connection to country, they could not be removed. That gets us to this. What happened in 2010 was we, under instruction from law people in the Central Desert, we created the original Sovereign Tribal Federation as a federation of tribes around the continent who want to stand and recognise each other's song, dance, ceremony, sovereignty, everything. Our lands, each other, the whole lot. And stand against the Crown as a common enemy. Well, what happened was that when we started the recognition process, we wrote to them and told them because we were not recognised in their constitution, we had no recognizance, and therefore there was no binding between the tribes on this side of the fence and the Crown on that side of the fence. We were trying to get them to admit that there was them and us, because by them and us it means that us are first in time. They are second in time. So what happened was that ultimately the Parliament raised the issue. Julia Gillard came out 6 weeks after we issued that notice, and she said that she'd been told by the government solicitors that they had to have a referendum to amend the Constitution to recognise Aboriginal people to bring us under their law. Tony Abbott was quoted as saying, "We have to do now what we didn't do 100 or 200 years ago. We have to bring these people under our law," publicly admitting we are not under their law. But anyway, on the 13th of February 2013, the Federal Parliament held a recognition day, and they entered a recognition bill into their Parliament. And at the moment they entered their recognition bill into the Parliament, the tribes, who are the sovereign member tribes of the OSTF, filed this document into their Parliament as well. Okay, so this is the document that they were served, and they were viewed and videotaped on the world by the world's press receiving this document.
You thought I could talk.
Believe me. Believe me, I do not like doing this at all. But this was a declaration of self-determination and nationhood of the autonomous original tribal peoples of Terra Australis. And for those who don't know, we are not Aboriginal. Aboriginal being a compound noun that means not original. We are not Indigenous, because Indigenous comes from the Latin indigena, meaning a naturalised citizen of the realm, which we are not. and we are not native, because native comes from the Latin nativus, which means someone born in a condition of slavery or servitude. So we take grave offence to the Crown's native title legislation, for example, where they try and get us to agree that we have traded our land. The term traditional owner coming from the Latin traditio, meaning someone who has traded their land.
So they're all frauds.
Hey?
Yeah, the Aboriginals and the Indigenous, they're all frauds.
Yeah, they are. Excuse me, blind is bad. To all and singular, to whom these presents shall come. We, the autochthonous and original tribal peoples of the Great Southern Land, the noble peoples of the Great Southern Land known in the modern era as Australia, support and address the United Nations in that we solemnly proclaim the United Nations Declaration on the Rights of Indigenous Peoples as a standard of achievement to be pursued in a spirit of partnership, truth and mutual respect. And we might say that we only recognise it as the lowest possible common denominator in a level playing field and a respectful playing field to move forward.